Again,
background where background where
background.
Extra intention, page number 1, page number 29. Page number 2, page number 7 to 21. Page number 3.
Item 35, ma'am.
Item 35.
35, I'm appearing for respondent. In fact, R3 died. I will inform the other side. I'll give the particulars. It may be taken up after 2 weeks.
Respondent counsel present to inform the task died. And he has to furnish the details of their loss to the appellate counsel to bring the loss on recorded request. List on 1912.
Obliged.
My
Thank
lord,
you.
item number 14, my lordship.
27. From the other side. Inform them. At the request of the appellate counsel. List on 14.
My lord, item 39, my lord.
39.
My lord, I am for the appellant.
Okay.
My lord, this is coming for the first time. Your lordship may kindly grant to 2 weeks, my lord. I have to, my lord, get instructions from the party. My lord, she is a old lady. Whether I have to
At the request
latest position at
instructions from the party. List on
Item,
11, 12.
item 24, my lord.
11, 12. Yes, 24.
much obliged, my lord.
Yes, my lord, in this I am appearing for respondent. In this appellant number 1 died, my lord. It's a long pending case. I am asserting my client
Who died?
to furnish the particulars, my lord. So kindly
Who
grant 2 weeks time, my lord.
Who died?
Appellant number 1.
First appellant died. You are for respondent.
Yes, ma'am.
Respondent counsel present and stated that first appellant died. That, to bring the loss of the appellant on record. List on 1812.
Yes,
My
ma'am.
lordship.
Obliged.
My lordship, item number 14, my lordship. My senior met with an accident and I have informed the other side. May I request it to be posted after 2 weeks, my lordship?
Request of the appellate counsel. As the senior is under list on 1912.
Obliged, my lordship.
42.
Milord, item 44, Milord.
Item number 42. You are for? You want time? At the request of appellate. At the request of the
Milord.
respondent counsel. List on 2811.
Milord, item 44, Milord.
Yes.
44, Milord.
Okay.
Milord, this matter lodged may have it after 2 weeks, Milord. I inform the council, Milord, other side council.
Request of the appellate counsel. She inform other side. List on 1412.
Much
Yes.
obliged, Milord.
45.
We will be doing it next week virtually. That is what is informed. What is senior counsel?
I want to argue virtually. Simple matter.
What is their senior counsel?
Suit for require respondent counsel present and stated and requested time on for the appellate counsel. List on 2111. Yes. For the mind. Second appeal. List on 17. 1711. Yes. 14 MSC. List on 2211. Right.
Next one.
2111. Right. That is some case. Item 49. Items 49 to 66 are settled in the local adalat and awards will be passed as per the terms of the local adalat. Right.
M1, A. Jagan, P. Satyavarma, P. Prakash Reddy.
Like the payment. So, this case of injury. Then TSHC 25,000. Below awarded. Only 1,85,000. So today, the TSHC 2 doctor, then there was a fracture the ribs and it requires future surgeries also. And admittedly, he was TSHC 1. He has paid nearly 1 lakh. But the title was awarded only 80 lakhs, only 17,000. Documented page 8 of the award. He spent nearly 1 lakh in hospitals. That was disputed and only 20,968 was awarded. And in respect of those fractures, the doctor categorically stated that he requires further discussion.
What was he doing?
Because
Injured witness, what is his occupation?
his occupation is also business.
Yes.
He is the only age of about 22 years in the accident is occurred.
ఏం బిజినెస్ చేస్తున్నారా ఏం బిజినెస్ చేస్తున్నారు
The accident is occurred on 28/8/2005.
వాట్ బిజినెస్ హీ వాస్ డూయింగ్ సో నో డాక్యుమెంట్స్ ఆర్ ఫైల్డ్ టు ప్రూవ్ హిస్ ఇన్కమ్ బట్ యువర్ క్లెయిమ్డ్ ఇన్కమ్ has 5,000 per month.
7.5 interest was awarded. The video was to appeal. The medical expenses.
నేచర్ ఆఫ్ ఇంజురీస్ ఎక్కడ రాస్తారండి నేచర్ ఆఫ్ ఇంజురీస్ అటెస్టెడ్ కాపీ ఆఫ్ ది ఇంజురీ సర్టిఫికేట్ A2 వేర్ ఇస్ A2 నేచర్ ఆఫ్ ఇంజురీస్ 21 రాయలేదు ఇంజురీస్ రాయలేదు Para 21 లో nature of injuries రాయలేదు. They simply stated grievous injuries. All the injuries are grievous. Para 20 injury certificate issued by government hospital. Para 21 లో లేదండి చదవండి. Para 20 చదవండి. Let the clinical committee observation website just and
Injury certificate issued by the government hospital on basic duty and treatment private hospital as due to the executive people to the state. So sustained approach depth test X-ray shows the second website with harmonic some fascinated to support the injuries, the patient and the expenses that report will be treated to one. The evidence of the medical
Who is another?
officer.
Where is another sir? Who is
For the consideration. The medical officer of the hospital takes the draw. According to the medical, he is an orthopedic surgeon and he examined the experience to one on 28 and noted the injury shown in which according to
Where is other side and respondent counsel on that? Insurance counsel is not there. Which insurance company? New India Assurance Company. Not there. Yes. Look at Pralida. Are the arguments of the petitioner counsel for respondents' arguments? List on 911 for respondents' arguments. Yes, next.
Item 2, C. M. Panikumar.
What happened? Notice is not at written. Petitioner counsel present, personal notice is already ordered. Personal notice is already ordered. Advocate ఏం చేస్తారండి CCలో? It's a contempt case కదా. That is for you to inquire. I'll issue fresh notice. You can inquire the address from the council and then issue notice to the fresh address. Advocate ఏం చేస్తారు? Contempt case కదా. You cannot take contempt against the advocate. At the best, you can inquire address from him. At the request of the petitioner counsel, issue notice to the correct address. List on 11/12. Yes.
Party is trying to obtain an order, but the Ryan and Navin were not. Party as part. The order should also be against the order, Ryan and RTO, not against the Kevalam. But at the time of decision of at the time of application, Kevalam was causing the concern. But particularly it has been changed, and Ryan and Navin is the concerned order.
Then
There is a final petition.
that's not there. Petition for deleting the name did not put up with the file. No, ikkada delete. Put up. It's not put up with the file. Others are notes ichara.
Yes.
Right. But it should be put up with the file. Both the council present. Responding council station that presently the content RSC, MRO Rajendra Nagar, but not MRO Chevrolet. And he filed an application, Adivana, Adivo Rajendra Nagar, but not Adivo Chevrolet. And he also filed a petition, but the petition is not put up with the file. Listed on 10/11. One petition was let it come on record. Right.
Item for the R, Lakshmi Narasimha, details about it.
Both the matters. Okay.
My lords, in item number 5, my lords, I'm appearing for respond number 1, my lords.
Wait. He is advancing arguments. Right.
Instead of students who can speak about it, and not give about it, not give about it, speak about it. And after because speak the one. Then after one people. They speak about it as close to the again, to avoid another.
Yes.
During that time, it was good. It's very clear to make it best that the
Commissioners.
on closest.
Add the petitioner counsel. Petition notice to the respond. Here for respondent is, okay, చెప్పండి. Para number?
Page 4 and para 6, para 8.
Para 8, right. Yes.
Page 4.
Yes, yes. Okay.
So, again,
Yes.
Therefore, scope is not equal to 50 with the elevation of the possibility and force. Therefore, the civil limit is discussed. However, the budget is granted is like the whole specifications to the plan. Hence, the application is low for that. One but not the land covered under the A1 segment A, but land is the page state petition in single grounds. I mentioned that that was expressed that this one is taken objection that was under the same is here is not following finding given the land then petition traffic not test again in the 20 is not test. Offense will be that the third project that the third petition. The third petition, but when so to someone submits the production of the records and the SNIA was full and very significant. That will be by the court by it. For appointment of advocate and commission, note of legal that is something here was finally and here was allowed and the ethics commission was appointed as court petition 7/2023 and the ethics commission appealed on 4/2023 and she successfully then counsel for the special priority insisted him to spend the filing in the commission to take the photographs and also measure some property which is against the condition warrant and also artificial travel. Therefore, he submitted that he could not take the warrant. So warrant was spread by the commission after hearing the both sides. The other commission petition quoted for master articles of 34/23. The suit is belongs to 2012 and the petition not cooperating with the advocate commissioner and the main suit is coming up for petition of other units. Therefore, suit is passed article. Now, again, the petitioners in agreement that you prepare say that against the idea of the petitioner and there is no stay granted pending. However, the confidence of those kinds, with the confidence of judicial officers, the other portfolio is stated that the suit was to be disposed of within 3 months with the license of the portfolio. And the matrix of May 2014, I think it is in the top 3 of the case. Even though informing the same petition fails to find other evidence, then even after giving fair and sufficient efforts, they would finally get the other evidence of the closed and suit was put for the respondent. Then again, the petition finds this is the present petition reopen the suit for this further evidence.
the findings of those court is giving their bad copy. So court is giving fair and sufficient of now replacing and taking steps by the court further. The principal is filing petitions one after another. Therefore, as the decisions about the court is not finding the reason to allow this petition and this as this court has given sufficient time to the petition to implement the same. Therefore, nothing but based on the value of the process law. Hence, the petition should be attributed to the petitioner. Yes. Now, he has court petition. And also the insisting Advocate Commission, instead of my reference in that, he is something insignificant. He is a big program. And the CRP, the advocates appointed. Now again, without implementing the opportunities, thus we wait to the process for the fight with chief minister. Then also the other court as a killer, opportunity to be disobeyed. This is a suit of the world. There is no minus concept to allow this disability to divide up.
Yes.
Okay. Yeah. One of the grounds. Every time I find it in the set up study of the company.
Right.
It was the same petition. Nothing was filed. He is interested in the case. You know, but the petition to avoid nothing to get away. Nothing. That is not the subject matter of this case. Here the author most are responsibilities are doing that. Then the court has closed that. That was the finding given in the area that the lordship may see. Case number 14. I have submitted that. Fixing the date and time for each. Yes, I will do it. According to this document, I have few things goes in my document. Let's look at it.
Right. Other CRPs. Other CRP item 5.
My
Not
lords, in this, I am appearing for respond number 1, my lords, item number 5. I have filed wakalat, my lords. Kindly grant me 4 weeks time, my lords. I'll file my counter, my lords, in this matter.
You filed. Yes, Chapman. Item number 5, Chapman. This will reserve for orders. At the stage of numbering. What is the objection taken by the office? Mm.
My lords, in this matter, papers were also not served, my lords. I need to
Papers
file
not
counter,
served?
my lords. Yes, my lords, not served.
Not served. Serve the papers. You can get ready with the main CRP. No counter is required. Yes.
Yes, my lords. I'll file, my lords. Kindly grant 4 weeks time, my lords.
For the council present. Petitioner council present. Written of the plaint. Petitioner council is directed to furnish copies to respondent council for hearing this 2011. Yes.
Oblige, my lords.
Item 6. Declaration. Line 46. Answer.
Insert.
Understand. Notice nothing. On last 2 cases survived. First
and answered and answered డోర్ లాక్ అని వచ్చిందా సార్ వాళ్ళు లేరని వచ్చిందా ఎండార్స్మెంట్ ఏమి వచ్చింది ఇట్స్ నాట్ సార్ ఓకే సార్ peaceful position. Insufficient evidence.
Masjid managing committee.
No going order secondary house number on the
ఇక్కడ ఒక డబ్బా పెట్టేశారు రీజన్స్ రీజన్ ఏదైనా టిక్ పెడుతున్నారు ఇన్సఫిషియంట్ అడ్రస్
insufficient address.
రిటర్న్ చేయడానికి రీజన్
Sir, and the rest appellate cause. Suit for eviction and recovery of eviction was declared in the transport but reversed in the appeal against which second appeal is filed. Appellate counsel did not stand. Appellate counsel is no more. Notice issued to the restaurant. Notice issued to the appellate returned with an endorsement insufficient address. Notice was served upon the address provided in the suit. As the appellants are not evincing any interest. Even after filing second appeal, no purpose is served in continuing the same. Moreover, a second appeal is of 2004. As such, then ముందు రాసుకున్నామా ఏమొచ్చింది returned in endorsement insufficient address but the notice is served to the address mentioned in the suit. Second appeal is of 2004. As the appellant failed to evince any interest, no purpose is served in continuing the same. Accordingly, appeal is dismissed. Yes.
Item 7. Notice రాలేదు.
ఇంకా రాలేదా ఎప్పుడు ఇచ్చాను 7 directed enter appearance on or before 7/11/2022. 7/11/2025. Suit is for recovery of possession. Declared in the trial court. But reversed in the appeal. Same వస్తుందమ్మా ఇందులో ఇంట్రెస్ట్ కూడా నెంబర్ హౌస్ నెంబర్ లేదు.
మళ్ళీ సేమ్ సర్వ్ అయింది. నెక్స్ట్ కేసు లో సర్వ్ అయింది అడ్రస్.
అదే అడ్రస్ కి ఒక దానిలో సర్వ్ అయిందా?
రెండిట్లో సర్వ్ అయింది. లాస్ట్ 2 కేసెస్ లో సర్వ్ అయింది.
Notice sent to the appellant. The counsel is, as the counsel is no more, notice is at, notice sent to the appellant. But it is not yet returned. Appellant was directed to appear before this court today. Notice sent to the same address was served in other 2 cases. As such, it cannot be said that there is no knowledge to the appellant regarding the pendency of the second appeal, as he failed to turn up and evince any interest. No purpose is served in continuing the same. Accordingly, the appeal is dismissed. Right.
సర్వ్ అయింది. సేమ్ అడ్రస్.
Notice served. First case లో కూడా notice sent to the same address was served in other 2 cases. Item number 6 లో కూడా అయింది. But that it same. This is suit filed for recovery of amount, recovery of possession. Decreed in the HIGHCOURT. Reversed in the appeal. Against the second appeal is filed. And as the counsel is no more, notice addressed to the appellant. It was served upon him, but that did not turn up. As such, no purpose is served in continuing the second appeal. Accordingly, it is dismissed. Next item kuda same.
సేమ్ అడ్రస్.
అంతే. నోటీస్ సర్వ్ అయింది ఇందులో సేమ్ వస్తుంది. రైట్. డి కృష్ణమూర్తిని. Gave no objection, already dismissed. Dismissed as abated.
Rushi Reddy filed
Restoration వేసారా? You are for D. Krishnamurthy. You are for appellant. Second appeal is dismissed as abated. Yes, for filing counters in the IS. List on 2411.
ఈ ఆర్డర్ అయితే కానీ ఈ అడ్వకేట్ పేరు రిఫ్లెక్ట్ అవ్వదు.
2411. Who gave no objection? D. Krishnamurthy gave no objection. That was recorded and dismissed. So you need not come and represent. It is for the other advocate who came on record has to make a representation. You are a new advocate.
Yes.
After NOC.
Yes.
But it was dismissed. Okay, let him file counters. Serve the copies of IS to him. Right. Listed on 2411 ND.
కేసు వేసింది రుషిక్ రెడ్డి అండ్ పేరు ప్రింట్ కాలేదు అంటున్నాను.
Print the name of Rishik Reddy. Print the name of Rishik Reddy. As the previous counsel gave NOC. Right.
Item 11, Sri Hariharan, Sri Naresh Reddy, Sri.
Name print చెప్పండి specific. Other side is there. Any objection? R5. LRs. Anybody? Not there? You have served notice to others. Notice to the other side. Not
The
that.
partition to the lodgement and the applications. We get it for finally in the.
You served notice to the other side, but they did not turn up. You are for appellate? Appellate counsel present, respondent counsel is absent. Notices and IS were served upon them, but they did not turn up. IA 1 of 2023 is filed to condemn the delay of 25 days in filing an application to set aside the abatement of R5. Considering for the reason stated in the affidavit, IA is allowed. IA 2 is to set aside the abatement, and it is also ordered. IA 3 is to bring the LRs of the R5 as respondents 10 to 12, and it is also allowed. IA 4 is to condone the delay of 28-110 days to set aside the abatement of LRs of to set aside the abatement order R9, respondent number 9, for the reason stated in the affidavit. IA is allowed. IA 5 of 2023 is to set aside the abatement, and it is ordered. IA 6 is to bring the proposed LRs of R9 as respondents 16 to 19, and it is also allowed. RA and IA 7 of 2023 is to set aside the abatement order regarding respondent number 8, and it is allowed. IA 8 of 2023 is to bring the LRs of R8 as respondents 13 to 15, and it is also allowed. This is the matter for final hearing. ఎప్పుడు చెప్తారండి? 14/12.
Identified PC Kumar, Sri Krishna, Department.
Who died? Other side, notice serve అయిందండి? You serve notice? రాలేదు ఎవరు? Correct address. Not claimed వచ్చింది ఎవరి దగ్గర? R5. No such person ఎవరు? Councils లేరా అండి? Council is not there. R13 to 21. Returned as no such person as per postman. Is one of the party. No? మీ పేరేంటి? You are there? మీరు ఇందులో ఉన్నారా ఈ కేసులో? మీ పేరేంటి? What is your name? Muhammad Abdul Rahim. The Irfan is there. Irfan కాదు. His name is not there. The son of
Muhammad Jamal.
is not a party. Children ఎవరన్నా పార్టీస్ ఉంటారు. Muhammad Jafar. Muhammad Jafar. Yes.
My lot of this is the R3 and R3 pair.
Hmm.
R3 pair.
Ramya Raja.
It's my lot of this is the R3 and
Muhammad Jabbar. Father పేరు ఏం పేరు అడగము. R1 present. Notices of other persons were not served and we had to file proof of the same. R1 present. R1. Party in person present. You are for? Councillor R4 is also present. Notices sent to the other respondents were not returned. Notice of R5 returned has not claimed. Notice of R6 to R11 served. Notice of R13 to 21 returned as no such person. So you should take some necessary steps. R13 to 21 no such person unchindandi. So you should take necessary steps. R13 to 21 no such person ante mari substitution edana chesi. For taking necessary steps to file substitution service list on 21/11. 21/11. And చెప్పండి either he should engage the advocate. Right. Papers not sent. Review petition ఏంటండి? 129 days delay. ఏంటి review? Hard copy అది. Review ఎవరు వేశారు? అవును, review ఎవరు వేశారంటూ? Claimant filed. ఏంటండి, what is the ground for review? ఎవరు మీరైనా వేసింది review? మీరు వేశారు. ఏంటి, what is the ground? On what?
It's the injury case. Whereas Walter was deducted wrongly. It's not a death case. And it's a death case, Walter deducted was possibly finished. So that was erroneously false. Second aspect is wages were considered lower level.
ఇంకోటి ఏంటి? Another
aspect is wages were considered at low level. That is 15 per month. Loss line, he was doing marble laying works and he was therefore treated as a skilled laborer.
Skilled labor, capable of earning.
Just above 95. Records show that he was doing marble laying works and therefore he becomes treated as a skilled labor. While considered skilled labor,
He cannot be treated as a skilled labor capable of earning higher income. Para 11, last line. Para 11, last line. He cannot be considered. So they have taken 1500 per month. 1500 per month cannot be altered.
case considered 6,000 pilot for a vegetable vendor unskilled labor.
Insurance, you are for insurance. What you want to say on this aspect? Anything? Sir, paper search చేయండి. ఇట్స్ ఓన్లీ రివ్యూ అండి. రివ్యూలో ఏం చెప్తారు మరి మీరు? వెజిటబుల్ వెండర్
Yes, we, there are we. Considering the present state of economy and rising prices in agricultural products.
6,500 per month.
It will be careful about 6,000 per month.
This is 2040. This is 2011. Right. Anything you want to object? Any objection you have?
Yes, sir. That's why I explained that.
One is only regarding that the deduction of 1/3. Injury case deduction will not come. And this is basing on the judgment 6,500. What else you want to say?
Actually, whatever last occasion only. That was
Heard the petitioner counsel at the request of the respondent counsel. A list on 1411. Right. Next.
Item 14, section 1912, item 15, N.K. Rajkumar, H. Prabhakar Reddy.
Yes, we can. Unloading the patient. And for respond.
Lot of applications. Nayama. Where is appellant not there? Respondent counsel present, appellate counsel absent. Petitioner to record a lot of them. This is first appellant. Who died? First appellant LR Sandy. Appellate counsel absent, respondent counsel present. IA1 of 2023 is filed to condone the delay of 411 days to set aside the abatement order in bringing the LRs of the first appellant. For the reason stated in the affidavit, delay is condoned. IA2 of 2023 is to set aside the abatement order, and it is ordered. IA3 of 2023 is to bring the fifth petitioner as LR of first appellant, and it is also allowed. For final this month or next month. 15/11, 15/12. List for final hearing on 15/12. Next.
Item 16, the G. Bhaskar Reddy, the P. Sriraj, the N. Harina, the S. V. Ramana.
Receive documents ఏంటి? Review application లో receive documents ఏంటి? ఉన్నాయమ్మా? Yes. What are the documents to be received in review application? It was disposed of. Review లో ఏముంటాయండి receiving documents?
I seriously object to me.
Review లో receive documents ఎలాగా? 2003 appeal. You filed review application in the year 2020-22.
2023, the Honorable Supreme Court was pleased to dismiss the SLP also, minutes.
SLP was dismissed. SLP on what grounds?
Same grounds.
Before disposal to ముందు వేసింది పొరపాటున ప్రింట్ 1/18 రిసీవ్ ద
Already.
That was dismissed, Millard. Millards were pleased to dismiss IA 1/2018, which was a document petition filed under Order 41, Rule 27. And the question of again receiving the same documents does not arise, Millards. So there, I'm sorry, Millards. Even review is not maintainable on that additional evidence petition also, Millards.
It's okay. It was wrongly printed.
delay and review.
Delay and review. Both the
The
council
document-
present at the request of the appellate council. List on 15/11. Get a
It-
reminder on that.
May I brave Millards to put it to 16th, Millards? For counter, if any, also because there is delay condemnation petition, Millard, any that would be only to assist the Honorable Court, Millard. for counter and hearing finally, my lords.
Yes,
Subject to my lords.
1611 for count and hearing. Ask
Deeply,
him to get ready with the matter on that day. Right.
deeply obliged, my lord.
Item 17, leave bargaining, leave it.
Yes, appellant for the whole item. The last application, to set a third application, and factor the length.
Other side is there. You have served notices to other side.
So, I think. All these three.
Already allowed. Allowed.
Yeah,
One placing should not be printed, I think. Look at pending.
Implead application. Implead application was not decided. Implead la counter వేయండి. Who filed this implead application? They you filed. Other side has to file the counter. Then only will. Others are allowed. Respondent, you are for respondent. Appellate counsel present. IA for implead application. For filing counter in IA for implement for implead application and for hearing list on 2211. Respondent counsel absent. Next.
Item 18, the L. Prabhakar Reddy.
Notice already sent and not served. They might not have turned on me. Now Vakalat filed till date. Notice served. Emma? Notice long back served, but they did not turn. What can we do? We can argue, we'll decide it. Appellate counsel present. In spite of service of notice, respondents did not turn up and set ex parte. For hearing the appellate counsel based on 2111.
Item 19, the N. Papa Reddy, the Liliana Sharma.
Last time you said that you addressed a letter to the client, it was returned.
Now we are also not aware if the possession is still there or only one.
Last time as a last chance, it was given. Posted for arguments. Shall I record the same and then dismiss it? Last time also you said that you are sending, but they are not coming in contact with you. Then what is the purpose of? No, today we'll record it. Already posted as a last chance. How many last chance will be there for you? How many last chance will be given for you? Suit for injunction, they might not have interested. Suit for injunction was decreed in the trial court. What happened in the appeal? Appeal is dismissed. Concurrent findings. I'll dismiss it. Already given last chance. How many last chances will be given? Appellate counsel present, respondent counsel absent. It's a suit for injunction decreed in the trial court and confirmed in the appeal. Against which second appeal is filed. In the previous adjournment, appellate counsel stated that they are not in touch with the clients, and hence it is posted as a last chance. Even today, she stated that they could not contact the client. As such, no purpose is served in continuing the same. Accordingly, second appeal is dismissed. Next.
Item 20, TSHC Babu, T.S. Krishna Prasad.
It is fine.
First respondent.
That's what. Unfortunately,
Appellant did not turn up.
yes.
Several times he is not turning up. You are plaintiff in the suit? You are plaintiff in the suit? Plaintiff is the appellant. You are defendant. Suit was declared in the trial court. In the appeal.
In the appeal, in my way.
Okay.
Against the second appeal, 45 meeting.
Respondent counsel present, appellate counsel absent. So a suit for injunction was declared in the trial court but reversed in the appeal. Against the second appeal is filed. Appellate counsel. Last time వచ్చారండి. Appellate counsel absent. Memo is filed by the first respondent furnishing the details of the LRs of first respondent to bring the LRs on record. And list on 20th. 2011. Right. Next.
21, C, Anil Kumar, C, O. Manohar Reddy.
My lord, in this matter, my lord, some of the respondent died, my lord, as per my instructions of my client, my lord. Let the respondent counsel furnish the details of LRs, my lord.
What the counsel present? Respondent counsel is, you are for respondent. Details furnished. It is represented that some of the respondents are died. Respondent counsel is directed to furnish the details to bring the LRs on record. List on 112. You have to furnish the details. Change. Memo end. Right. Next.
C.P. Pratap Reddy, C. Pankaj Gandhi.
Where is appellant? Counsel for the appellant absent last time. Memo R1 LRs details ఇచ్చారా మీరు? Memo వేసారా? Where is the memo? Suit of 91. Suit for recovery of possession was dismissed in the trial court and confirmed in the appeal. Against which second appeal is filed, but the appellate counsel absent on 11/10/2023 and also today. Respondent counsel present. She filed and she filed a memo to the extent that R1 died on 3/11/2005. ఎలాగమ్మా దీనిలో డీటెయిల్స్ లేవు మీరు లివింగ్ బిహైండ్ 1 son 2 daughters and a widow అంటే ఎవరికి పంపిస్తారు దేర్ సో దట్ కెనాట్ బి కన్సిడర్డ్ కదా filed a memo on 17/2/2006 but the details of their loss with their addresses were not clearly mentioned. As such, they are directed to furnish the details of a loss. List on 412.
Item 23, the M.V. Durga Prasad, M.V. Anil Kumar.
I am for the respondent, my lord.
You are for appellant. One time. Other side is there. Both the counsel present. At the request of the appellate counsel. List on 1812. Next.
Item 24, adjourned to 1812. Item 25, Sri Narasimha Sharma, Brigade Srinivas.
Other side is there. You are for respondent? Not there. Appellate counsel present, respondent counsel absent. At request list on 1912. Next. 1912. Next.
Item 26, Sri A. Vishnuvarthan Reddy, Sri A. Narasimha Reddy.
Alert people last week, both will connect last week or probably will.
Other side?
So, Charles, respond.
Yes. You want to argue? You want to argue the matter? 2005 matter. ఇవాళ చెప్తారా ఇంకో రోజు చెప్తారా? Next week. Suit for permanent injunction declared in the trial court, confirmed in the appeal. Both the counsel present for arguments at request.
Response number 1 has expired. I went to them just for response number 1 has expired.
Both the counsel present. Respondent counsel stated. ఎలాగా? LR should be brought on record and he is furnishing. HIGHCOURT counsel, respondent counsel stated that R1 died and also furnished the details of LRs. Appellate counsel is directed to bring them on record. List on 2911. 2911. To bring them on record, then we'll see. Right. Elaga. They have to say something else, kada. You bring them on record, then we'll hear and then dispose of. 2911. Right. You are for respondent. You want it to be allowed. So second appeal is to be dismissed. That's what he is asking. It's a concurrent findings, though he want to the second appeal to be dismissed. That's what. 2911. Right.
1412, item 28, the end Shobha.
Of service not filed. Issue notice to the appellants on appellants 1 to 3 served as per postal endorsement. R1, R2 served. R3 not yet returned as per proof of service. Serve అయిపోయింది బట్ వీళ్ళేమో పుట్టప్ చేయలేదని served and రాశారు. Suit is for OS 12 of 2000. Suit claiming compensation against the government authorities was filed, but it was dismissed. Against second appeal is filed. ఎవరమ్మా అప్పీలెంట్ కౌన్సిల్ ఉన్నారా ఇప్పుడు? మరి నోటీసెస్ ఎందుకు ఇచ్చారు? Notices were not. The previous council for the appellants on record gave no NOC. As such, notice was issued to the appellants, but they are returned with an endorsement served. In spite of service of notice, appellants did not turn up and failed to evince any interest. Hence, no purpose is served in continuing the appeal. Accordingly, appeal is dismissed. Next.
Item 29, the RA experiment.
Has to argue.
What's the out of a concrete vacuum, the most effects have decided. The expected staff is good.
You want to cite now or in the reply arguments?
If this happened on business, I will agree to the reply.
Are you ready with the arguments today? R1 is there. Why? You yourself asked in the last adjournment. Mere చెప్తానన్నారు citations చెప్పాను. Right. It's posted for arguments of respondent counsel. Actually.
I raised two primary contentions before the court. One was that Snowden did double the contempt respondent. Not required. Was my contention so far as the gift was concerned. The second contention was raised on the commission, which was raised by you all, that people in registered instrument. Now, what they say that with the registered instrument, so far as the mother does not get any total right because my contention was in case if the court finds that the mother probably was not totally influenced by her husband, that my father to my mother, then whether the instrument can be set aside by the court or not, instrument can be set aside for the contention, primary contention so far as the issue was concerned. Lordship, let's look at the specifically fact, that is specifically fact. Suppose the instrument can be set aside to the extent of the payment share, not to just look at 32. Section specifically fact.
Section? Yes, section?
This is the third judgment. So that is 0.7020, para number 20, para number 14. Seven deals with the provisional phase. That is how para number 8, that is 14, value. Double line for 20. The bottom second element. So the bottom second also got it. Five here, civil asset number 15147.16. 5147. So the
Para numbers.
para number also you just look at para number 7. Para number 7, where the provision section 31 is cited. The calculation paragraph runs to payment page. Area developers and all the identity portion.
Para number 7.
7. That is when instruments can be maybe ordered. That is section 31 is written. So the bottom second judgment.
Para number 7. This brings us to the interesting argument.
Yeah. Yes, this next page.
Yes.
Next page.
When cancellation may be ordered.
Yes. Next page. 14 is the run of the judgment.
Yes.
With an area developer, they have extracted the
Right. Right.
Under section 31 of the specifically Act, the legislation confers the powers on board to send a copy of instrument degree to the officer in whose stocks of it the instrument has been registered and the officer notes the loan on the instrument contained. So the fact of its cancellation, it is evident from the provision under section 31(2) that the power of nullifying the effect of the registration is conferred only on the court. In the judgment in Woods and case, the court has said that right in rent against the word and contrasted to the right protected solely against the specific individual and action is personal. The action determining the rights and interests of the party, they themselves is the subject matter of the case. Whereas the action determining the right of the property and the rights of the parties, not merely among themselves, but also against all persons at the time and their property. In the case, in the said judgment, it is clearly held that the education is dealt in them only public fora, that is, courts and tribunal can have certificates and dispute and again, as such, the development agreement come minimum of money is a registered one and it is in relation to the property. Any cancellation will remove the rights of the party. The cancellation is to be done on the registered document in view of the government section that you therefore, we cannot consider you that the identity function in cases like this will operate in any regard to power conferred on the court by section 31 of the Specific Act. Only a competent court can then the cancellation decree to the effect the statutory power is conferred on the court. Such power cannot be exercised by an arbitrator in spite of the fact that there is an arbitration clause in the agreement entered between the parties. We just come to the next page. Conflicts in the court's observation. Also, we just look at page number. That is 13.
Yes.
13.
13(1)(3).
Yes. Sir, I'm sorry, sir. Just what we just go to back to 24 state. Continuation of the entire case is the list of the lot of we just look at Parliament, so that the answer is looking for the answer the other condition. Parliament very. Where the executive process was very he wants to and wants to get it. You can see cancellation doctor and pay, but if the non-executive notice is what? 6 amendment of the deed.
Para number 24.
Para 24. The passage of para 24 of the applicable judgment has been like before. So we please see that index para 24. Let's go para 25. In the same judgment. Para 24. Also, it is an instructive judgment of this court. I think it's not clear.
Right.
Yes. So, this thing was the releasing. That's also where he wants to get it, wants to be annulled. He has to seek cancellation of the deed. But if the non-executor seeks annulment of the deed, he has to seek a declaration that the deed is invalid, honest, or illegal, or that it is not binding money. The difference between the prayer of cancellation and the declaration in regard to the deed of transfer and conveyance can be brought out by the following illustration relating to two brothers. A is pure of fee. Subsequently, A wants to avoid the sale. He has to sue for the cancellation of the deed. On the other hand, B, who is not an executor of the deed, wants to avoid it. He has to sue it for declaration that the deed executed by A is not invalid, void, honest, illegal, and it is not bound. In essence, both may sue to have the deed set aside, declared, and non-binding. But the form is different, and the court fee is different. If A is the document is cancellation of the document, he will pay additional court fee on the consideration stated in the sale. If B wants to non-executed, non-possession, super regulation, the deed void or void does not bind him to again on his share. That's what I'm trying. He is made exposed to this one. The extent of the share only of my contention. So and so. But be a non-executor, he is not in possession and he wants to get not only declaration that they are not invalid, but for consequential leap of possession, he has to pay 713 or the act. So my submission would be that the next paragraph number 25 also is on the same proposition the 19%. So what should we just look at paragraph number 73? That is the English judgment. Next judgment, that is Chhattisgarh High Court. Manu CG 028 2022. Paragraph 26, 27, and 28 will ask all of the judges. Paragraph 26, 27, and 28. What was the next is that paragraph 26, Washington State Council. Further, the council, learned Banco has cancelled the same beyond the extent of so of the land, while it was authorized under Part 1. In order to find out the answer to the question, but the trial court was justified partially cancelling the deed. The principles of law laid down in Murgam versus Keshav, the counter, two legal representatives also. The Supreme Court has quoted except from silence on jurisprudence for the edition. Para 15 read as follows. Yes, sir. This is valid, void. The valid document is one which is fully operative in accordance to the intention party. A void sanctioned. The declaration will of the parties will only restitute to legal efficacy. A viable instrument stands midway. It is not nullity, but operation is conditional and non-absolute. This is what the 27 has held into the same pattern. The state is not going to say that it is out of a fraud. What would be valid of the same thing when it exceeds the area given under power plan? The principle would be covered like that. The sale of the property to the minor. The disposal of input property to minor gained by the national government is voidable. It is valid and avoided in accordance with the rights conferred by a registered sale are who we have against the whole of the world, and the sale can be avoided in case of the property sold by a minor by national guardian and the instance of the minor or by person claiming under what is set aside from before taking this sale. The distinction can be made between cases where the document is wholly or partially invalid, so that it can be disregarded by any authority or court authority. And one way it is actually set aside before it can cease to have a legal effect. Therefore, the allegation made in excess of the power or to transfer would be of the extent of the excess of power is invalid. Then article just look at para number 24. We have noticed that in subsection 2 of it refers to disposal of removal of in contravention with the subsection 1 section 2 of Article 5. When a registered sale is voidable, it is a valid thing. Was it policy, not the rights conferred by the registered sale. Article its whole work and the city can be awarded in case of property sold by minor and Malaysian government and instance the minor or any person takes it. A document which is voidable has to be actually set aside before taking a legal effect. The court in Gorakhnath today versus Harnasi the same Manu also by taking a decision to void we think that the distinction can be made between the cases where the document is only or partially invalid or that it can be disregarded by any court authority and one where it is has to be set aside before it ceases to have a legal effect. In excess of the powers to transfer would be the extent of the excess of the power in the environment. And adjudication on the effect of such purported allegation would be necessary to imply the decision of the dispute involved market change in that which are subject matter of the consolidation procedure. Now, ultimately, the court refers to that my submission would be set on the court of the trial court has totally cancelled the instrument of a gift being executed by the mother. So my submission would be said, I think this proposition will not fit in even if the court comes to the conclusion that would know that it was not established by the mother in a favor by her husband. Still, the instrument to the extent of the mother, because at last time it was represented that the mother passed away. Even if she passed away, no doubt all the parties to the dispute are the legal head. Still, the instrument can only to the extent of the daughters who fight the so claiming the shame property. The entire instrument cannot be cancelled so far as the interest of the mother is concerned. It would be my other submission. The last is for the first evidence, and I think there's a guiding judgment last time I cited to just look at the first one, that is Manu SC 0557 of 2011. Just before the balance and go to the relevant balance. That would be relevant. And the last time we just made a submission about the principle of Mohammedan law. I made 1213. Not you may just look at, please look at paragraph 20.
This is citation 2009 11 SEC.
Yes, 2000. First one, which I think is one in this look at it. Manu SC 0557 of 2011.
Page for book.
Just look at paragraph 20. 20. Yes.
Citation?
Yes.
Which citation?
Yes, that's the 21st.
Citation reference exception. Which citation?
One of SC first one. 0557. That is similarly 1714.5. Abiga PV versus Parika. The first one. Yes, that is
Now you find
today.
Hafiza baby, right? Right.
There's lots of interviews. 20.
Okay.
Yes. In Sankesh Chinna Buddha Prasad also 54 permitted HIGHCOURT are notes in TSHC of the case under Newton law was registration right. It requires registration under section 71 of the registration. When you hold that, even if by virtue of section 129, a deed of the gift executed by was not required to comply with the provision of section 150 of the TSHC, it has to be registered under section 71 of the registration. Relates to equal property for the to evaluate the judgment of the court. The earlier judgment referred to is to that argument to start 22 set highlighted portions. Highlighted portion, that is, it is an extract of a judgment of 72 Kerala 27. In that just highlighted portion, a Muslim can be valid even without a registered legal position. And may be invalid even with a registered the registration in irrelevant to the legal form. A deed setting out Muslim law and Muslim gift cannot be regarded as a constitution of a gift and is not compulsory registered. This would be contention, which my whole contention is about the highlighted portion. Then just please look at page para number 28, where both our principles have been but the para number 34. 34 where it is 34 of it.
Yes.
The extracted judgment of 84 Gawati. Next step. Now, so for the facts are concerned of the case, also 34. Now, as far as in fact, for the present case, the gift was made by Sheikh Dawood by a written deed dated February 68 in favor of his son Muhammad Yaqub in respect to the property Schedule A and Schedule B property appended to it. The gift as is recited in the deed was based on love and affection for Muhammad Yaqub as after the death of Jonah's wife, he has been looking after and helping him. Then it be said that because a declaration is reduced in writing, it must have been registered. We think not. The acceptance of gift by Muhammad Yaqub is also evidence and he signed the Muhammad Yaqub was residing in Schedule B property consisting of an house and a room in a particular land there too. Was physical possession of the residential house will be known. On the consideration of the entire evidence on record, has recorded a categorical finding that Sheikh Dawood's owner executed the gift dated 5th February 68 in favor of Doni Muhammad Yaqub. The Doni accepted the gift and the gentleman handed over the properties covered by the gift to the Doni. The trial court further held that the essential of granting gift under the Newton law was expert. The trial court is in accordance with the legal position stated by above. The gift dated so is a form of a declaration by the donor and not an instrument of gift as contemplated under section 7 of the Registration Act. As all the essential requisites are satisfied by the document enclosed, the gift in favor of the second dependent. This is what my the document which I provided to the court, where the Divanama was given. It regards a transaction under which an oath was given by the husband in favor of his wife. And it's not signed by the wife, it is stated in the document that it was accepted in the presence of witness. Now, unfortunately, the concept of the facts of the case is having number 34 for other facts in issue so far as the document is concerned. So ultimately, the document do not actually be registered document as held by the court. Ultimately, the only question was, sir, is a registered document as such? I cannot look into the document or the finding recorded by the learned technical trial. So my next submission would be, I think the entire purport of the really shows that a whole was given, which was referred therein, and the document was document specific by registration as submitted in one section 29, 129 of the TDA. And yes. So my submission would be that the emphasis laid by the bank that the document is not registered, as such the document is not valid, is not sustainable. And the second condition that the whole of the document has to be set aside is also gets into the back of section 32 of the Legal Act, where that even anything finding is not accepted, still the court gets accept the extent of the beneficiary. Not this so far as the extent. Mothership, most people have represented mother passed away on all the parties are on record. My submission would be that.
One has to appellate counsel and counsel of appellate counsel and counsel of R2 present. R1 counsel requested time for arguments. Appellate counsel submitted citations and argued regarding the citations. Now it is again posted for respondents' arguments. List on. Okay, that's what I'm seeing. They asked for time 1 week. Huh? Shall I list it on 20th? Monday 20th or 22nd? 22nd.
I can tell you the case and working.
So, but the appellate will not constitutional advance arguments. What suggests people plans event. The case of damages in the railways, with the other department authority. So they go to court, they can't allow the constitution directly between paid and suffering profit, somewhere more certain the legal aspect. But was not granted amounts. So I want to raise it.
Class 4-9 చెప్పారు 27-9 it is posted and again you are asking for time. You are for respondent. For the counsel present at the request of the appellate counsel for filing citations. When can you file? 17-11? Yes. 17-11 as a last chance. Already time was granted. Next. You are for? Last time. You are for respondent. Suit is for recovery of amount. What happened in the trial court? Declared. Suit for recovery of amount was declared in the trial court against which appeal is filed. Both the counsel present at the request of the appellate counsel. List from 21-11. R5.
And R2 also there.
You are for R5. Who died? R2 and R5. Counselor for. Both the counsel present. R5 counsel informed that the respondent number 5 and R2 died. We had to furnish the details. Details of LRs to be furnished. Details of LRs. So council is directed to furnish the details of the LRs. That's what I'm recording. Respondent councils are directed to furnish the details of LRs, and appellate council has to bring them on record. List on 7/12.
Item 33,
Yes, so I am appearing from the respondent for 5 years. After seeing the papers of 7 died.
R42
7 died.
died of. Both the council present, it is represented that R4 to R7 died. And you have to furnish the details, and the respondent council has to furnish the details of LRs. Respondent council is directed to furnish the details of LRs, and appellate council has to bring them on record. List on 14/11, 14/12. 14/12. Yes.
and 34, the medical notice, and the evidence.
So in this part, it's supposed to go. What was the granted because you pay off. Probably not quite that EP was not. Ultimately, if you complete amount has been paid,
This
was recorded.
the side is there. So it is for recovery of how much amount? 6,79,319.
This was passed by the.
Yes. Suit for recovery of amount was filed before the High Court and it was declared. Appeal is preferred. Against the said order. But during the pendency of the appeal, EP 16 of 20 is for 2010 is filed, and in an order dated 28/2/2014, JDR paid the entire decretal amount, and it is recorded as full satisfaction, and paid the entire decretal amount of 8 lakhs, and full satisfaction memo was also filed. The copy of the compromise. What is this compromise, Andy? Basing on the compromise, they paid 8 lakhs. The copies of the compromise memo, EP order, EP pocket order, and full satisfaction memo are filed before the court. As the EP is closed, this appeal became infectious and is dismissed as infectious.
Item 35, again to 1912. Item 36, Sri Ravindra Rao, Sri Ramchandra Rao, Eluganti.
Doesn't senior counsel's name, we would change the Vakala.
Who is now? V. Ravindra Rao is not on record. He became senior designate.
Yes, yes.
That was last time mentioned. So for engaging another advocate, it is listed.
We are trying to contact the client stage.
Your new advocate on record?
No, they tried the Vakala.
You have to file. Yes, both the council present for engaging another advocate and filing Wakala at request. List on 15/11, 15/12. Yes. Next.
37, the HIGHCOURT, I normally the doubt.
Files are written a lot, but the senior attendant,
Your for?
somebody who's petitioner, files written to the concerned.
You have, you have returned files.
Yes. Let us also that matter.
Ambapudi Satyanarayana is represented. On behalf of the appellate council, it is represented that they gave NOC and also returned the files. Respondent counsel absent. Tell us the name of Ambapudi Satyanarayana as appellate counsel. Suit for recovery of amount was declared in the trial court against which appeal is filed. But there is no representation by the appellates. List the matter under the caption for dismissal. On 17/11. Respondent counsel absent.
Item 38, the Challa Relation to the section page, the access power. Power for sensitivity of the
Resolution plan is approved. Accordingly, IA is allowed, stands disposed of. And NCLT law orders were passed. So this appeal is to, in view of the said order, appeal becomes infectious. For verification only it was given. Yes, both the council present. In view of the order of the NCLT, this appeal became infectious and is dismissed as infectious. Right.
Item 39, again to 11/12, item 40, the S Bhajan, Sri K.V. Subbareddy.
Record వచ్చిందమ్మా. Okay, we'll call for the records. Appellate counsel present. Call for the trial court record. Okay. Entire record is received. Yes. Page? Paragraph 3 of appellate court judgment.
3, 4, and 7. The court says, the period of 2 and 3 and not in PA1, PA9. And that's the rules of the defendant. Everyone need to do in P1 to P2. So kindly come to paragraph 7 now. The appellate court, both the parties filed additional evidence petition. Against for 217 of 272 of 2010. So, the document filed for part by consent. So you said numbering of is not correct. B6 to B26 no problem. A22, A28 is not correct because earlier they were only A1 to A9. That's for the record. Now,
so A10 to
at the end of the judgment, the additional evidence documents issued, they are not mentioned. But those records are not issued. And reading of the judgment would show that those documents are not ever considered by the appellate court. So additional evidence was taken on record. Therefore, those records will be confirmed. I applied for certified copies. The other day, they gave me copies.
ఇది ఒకసారి వెరిఫై చేయండి.
Copies, those copies
ఈ
are
డాక్యుమెంట్స్ వచ్చాయి.
okay.
B16 to 26,
In fact,
తర్వాత B22 to 28. ఇది ఒకసారి అప్పీల్. ఇక్కడ పేరా నెంబర్ చూడండి. పేరా నెంబర్ 7 ఆఫ్ అప్పీల్. అప్పీల్ చూడండి. అవి ఉన్నాయా లేదా చూడండి.
There is another government. Rating has sold away property already. He is not in possession. He was here for injunction. In fact, Talapa City's case, court said, even if suit is filed for injunction, there is a dispute with regard to some factors that can be left open at the later stage. That is not left open also by the court. Additionally, evidence filed by the parties taken on record by consent is not considered by the first applicant. So these subsequent events will have to be also taken into consideration in order to come to justice. There are 3-4 judgments of Supreme Court where they have said. Also, your copy, amendment petition,
ఎప్పుడు చెప్తారు? When can you get ready?
If you are marked as additional evidence of because they are not available in the registry also.
When can you get ready with the matter? So we should call for next month, Vesta. 8/12.
In fact, in the appellate court judgment, the end they have given the list also. So,
8/12.
there is a matter of institution, actually the problem.
8/12. Matter is listed on 8/12.
Proceeding sheet లో అవి మెన్షన్ చేద్దాం తెప్పించుకుని.
రికార్డ్ రావాలి కదా, ట్రయల్ కోర్ట్ నుంచి రికార్డ్ రావాలి. Call for
After records are issued, there is no problem at all. The record be
we'll verify.
In fact, I applied for certificate copy. These are the copies. Those documents are not issued this.
Call for the documents, exhibits B1 to A1 to also and call for the documents. So mentioned in para number 7, AS number so and so. Within 10 days. List on 8/12 అండి. Even 15 days log out just that. Right.
Item 41, ఈ కల్పన అయిపోయింది.
Requesting by everything is filed for requested time.
They want time. Both the council present at the request of the claimants. The list on 6/12. 6/12.
Item 42, item 2811, item 43.
Other side is not there. Insurance council is not there. Cases of injury case, sir. ఎక్కడండి ఇంజరీస్ ఏం వేస్తారు మీరు డాక్యుమెంట్స్? ఓన్ సర్టిఫికేట్ ఎగ్జిబిట్ A2 వేసి PW2 is examined.
Yes.
Lacerated wound.
Yes.
Lacerated left thigh. Lacerated injury over the right side of the forehead. Tenderness over pelvis. Lacerated wound over the wrist. The upper legs. 1 to 3 are grievous in nature. 4 and 5 are simple.
those increase in your worship. Page 5 your worship. Is wanted want your worship towards US business. 45,000 is awarded. Simple increase in your worship. Simple increase for 3,000 is awarded. Total 48,000 awarded or towards loss of funding, 1,000 is awarded. And towards medical expenses, 54,000 is awarded. School is their expenses. Three years were like toward 3 years, 5,000 is awarded. But he was in hospital for 22 days as a patient. Towards pregnant suffering of the great champions, isolation, explanation, those extra.
మెడికల్ ఎక్స్పెన్సెస్ ఎంత అండి? ప్రిస్క్రిప్షన్స్ బిల్స్ వేసారా? 29. How much they granted medical expenses?
Medical expenses totally granted
54,000. Then ఇది కూడా బాగానే ఉంది కదా. ఇంజురీస్ లో కూడా they granted 15,000 for each grievous injury. So 3 grievous injuries 45,000 ఇచ్చారు. Simple injury 1,500, 3,000. Okay.
loss of earnings 10,000.
ఏం పని చేస్తారు అతను? Twenty 22 days in hospital. Right. Slip banana. Slip కూడా మీరు ఇంకోటి appellate petitioner counsel present, appellate counsel present, respondent counsel absent. Heard the appellate counsel. MSCMA 32/34 of 2011 is filed against the judgment of the trial court in Gopi 727 of 2002 dated 19/12/2006. It's a case of injury. Petitioner claimed an amount of 4 lakhs for the injury sustained by him in an accident dated 10/4/2002. There is no dispute regarding the negligence. As per the evidence of PWC, he sustained the following 5 injuries, out of which 3 are grievous and 2 are simple in nature. The trial court, considering the nature of the injuries, rightly granted 48,000 for 5 injuries, and petitioners also filed the prescriptions, copy of the scan report, pathological report, and medical bills, 29 in number. As such, the trial court granted 54,277 towards injuries sustained by him. The counsel of the petitioner stated that he underwent surgery kodanandi. He underwent surgery and was in the hospital for 22 days. Considering the nature of injuries, this court finds it reasonable to grant an amount of 15,000 for pain and suffering, 15,000 for loss of amenities, 10,000 for transportation, 10,000 for extra nourishment. Attendance charges ఇంకా మీరేం వేయలేదు కదా. We have not filed any documents.
Um,
Client petitioner was working as RMP doctor and was also doing cultivation. The trial court assessed his income as 3,000 per month. Considering his nature of considering his occupation. And the fact that he is having agricultural lands to an extent of 3 acres. As he filed Exhibit 812, Patta Passbook, this court finds it reasonable to take his income as 10,000 per month. Due to the injury sustained by him, he might not have attended any other work, at least for a period of 3 months. As such, he is also entitled to 30,000 under the head loss of earnings. This we could actually already ఇచ్చినవి యాడ్ చేయాలి. ఇంజురీస్ 40,000 48,000 తర్వాత 54,277 కి ఇవన్నీ యాడ్ చేయాలి. నెక్స్ట్ రెండు యాడ్ చేయాలి. ఎంత అమౌంట్ వచ్చిందో ఒకసారి ఇప్పుడు మీరు క్యాలిక్యులేట్ చేసిన వాటికి ఆ రెండు అమౌంట్స్ యాడ్ చేయాలి, నాట్ 10,000. ఎస్ additional evidence వేశారు. This is appellate stage. What are the additional documents you are filing? You are for A4. You are for అందరు అప్లైన్సే ఉన్నారు.
I'm appearing for respondent number 13 and 14, Your Lordship. In item number 47.
13 and 14. You are for R5. You are for ఏమ్మా మీరు దేనిలో both the matters are one. ఇస్తున్నారు అందరు డాక్యుమెంట్స్. both the counsel present. Both the counsel present. Appellate counsel in item number 47 intended to both the counsel and item appellate counsel for A4, A6 in item A6 counsel in item number 46 and A4 in 47, and also respondent counsel 13, 14 and R1 in 46, 13, 14, R5 and R1 and 47 are present. Appellate counsel intended to file additional documents at request list on next month 13/12.
Obliged.
For the matters. Next. Am I or for? You are for? Where is respondent? Are you ready with the matter? వచ్చిందమ్మా కలిసి రికార్డ్ అయితే కావాలి ఇంకా ట్రయల్ కోర్ట్ రికార్డ్ కావాలి appellate counsel present, respondent counsel absent, only AS record received and suit record is not received at request. List on next month Vesta 1912. Any? First week means they have not received record of 1912. By guys, this 2016 matter. 1912. Register is directed to get the trial court record, so suit record. Record in voice number, so I'm one specific assigned cycle. And the AS switches in the voice number was the same. Any passed over matters? Second appeal. Partner.
Yeah.
Already awards passed అండి అవార్డ్స్ కూడా పాస్ చేసేసాక మాకు పంపించారు ఊరికే రికార్డ్ చేయడానికి మేబీ పార్టీస్ ఆర్ ఆల్సో ఇంట్రెస్టెడ్ వాళ్ళే చేసుకున్నట్టున్నారు యు ఎంక్వైర్ ద అవార్డ్ ఆల్సో పాస్డ్ యు ఆర్ ఫర్ క్లైమెంట్స్ మరి చూడండి ఒకసారి అవార్డ్ just see, look into that. Next.
Kindly leave, Millard.
Yes, it is item number 6. You are for?
Millard, I am sorry to interrupt. Millard. Item 52, Millard, I appear for the appellant. Millard, this matter is not settled, Millard.
That's what they are representing, but awards are passed.
Millard, in fact, there is a connected matter also, which is also an appeal filed by the insurance company that is not listed. In fact, to the best of my knowledge, these matters are not settled, Millard, because the insurance company never agreed for any settlement. This is an appeal filed by the insurance company, my lord.
Okay. Item number 62.
52, my lord, I'm sorry.
Item number?
52, my lord. But MACMA 513 of 2012.
52. 513. Awards are passed already.
I'm sorry, Millard.
With the signatures of the parties. Maybe somebody might have represented. Chuskondi ఒకసారి verify చేసుకోండి.
I'll verify.
You verify.
I'll verify. Obliged.
Insurance company represented that the company is withdrawing the appeal filed by it.
Yes, Millard.
The said representation is recorded, appeal is dismissed as withdrawn, confirming the judgment of the trial court.
Yes, Millard. If it is withdrawn,
deposited within 1 month, and they are permitted to. Award is passed. It seems that you have agreed.
I agree, because these are the instructions in which I was instructed to withdraw the appeals.
Yeah, that's what. Right.
I'm obliged.
Item. Right. 67. Afternoon, we have other bench. You are for appellant? Appellate counsel present and informs that senior is held up in a bench. List on. 1511.